send the YouTube. Oh, there we go. If you have a link, we can also share it in the chat for anyone who might be interested. Yeah. Well, let me actually just mute notifications here. Okay. Yes. We have a few attendees waiting in the room.
Oh, that you haven't let in yet.
Oh yeah. And also the background. Yes, we had. I forgot.
So I was just complaining about my background because it basically fades out all of my, not all of my, the little hair that I have gets removed by this background.
Yes,
Oh,
I mean it's like in 2026, still that sort of background thing is not working properly. When I do it really,
because this is a dark background, a relatively dark background, but still,
yeah,
somehow it gets rid of my hair.
really. I'm exaggerating, but typically a person's, one third of their head just goes away when you do the background thing, and yeah, I think they just stopped improving that feature.
But you all look pretty good to me, but
I don't have the background yet, so we'll see how it works. I had a new haircut, so I hope it doesn't mess it up. We'll see. We'll see.
I'm not going to comment on when I last had a haircut.
Okay. I have it. How does it look like? I think really the glasses, when you kind of like turn your head, the little sort of that area that shows the background is white. That's kind of funny.
Yeah.
Yeah. Okay. The background. Except my background is it like mirrored or is it correct? Okay.
Yeah.
Because I see my name from right to left on my screen. And so,
Oh, it looks fine for us.
okay. We can let the attendees in. I think let me just send out of yeah, apparently I don't have the permission to. Oh, we have attendees already in. Sorry, I thought it was a waiting room. Okay, so welcome everyone. We're being live streamed. My name is NS, and this is the ninth session of the live project, which is designed by Northern Justice Watch along with its partners, whom you can see in the room with us. Right now, we have very important guests. And we are exploring different topics in international human rights and international criminal law. And today's session, we have Toby Mandel, Joanne Hodges, and Sharab Turchin, who are very well-known human rights activists and researchers in Canada. Allow me to introduce them to you briefly, and then so we can get started on today's session. So, in no particular order, I will start introducing them. Toby Mandel is the founder and executive director of the Center for Law and Democracy, which is a Canadian NGO which provides legal and capacity building expertise regarding foundational rights for democracy. Prior to that, he was senior director for law at Article 19, which is an international human rights NGO focusing on freedom of expression and the right to information. He has collaborated extensively with intergovernmental actors working in these areas, including the World Bank, UNESCO, the UN, and others all over the world. Before joining Article 19, he worked as a senior human rights consultant with Oxfam Canada and as a human rights policy analyst at the Canadian International Development Agency. He is the author of a large number of articles, monographs, and books on a range of freedom of expression, right to information, and communication rights issues, including several books published by UNESCO. Next up, we have Mr. Sharap Turchin, and Sharap Turchin joined the Canada-Tibet Committee as its executive director in January 2018, after moving to Canada in 2015. He has also worked on development projects as an entrepreneurship specialist and proposal consultant for Alinea International in Gatineau, Dharamsala. Before relocating to Canada, Sharap worked with HSYWE in Nepal as an assistant director, focusing on empowering Indigenous women, and as Deputy Chief of Tibet Fund India, he oversaw projects supporting education in Tibetan schools in India and Nepal. Additionally, Sharap worked as a research analyst at Thomson Reuters in Bangalore. Academically, he holds a Master of Management Innovation and Entrepreneurship from Queen's University, Canada, and an MBA from India. We have Joanne Hodges here, another friend of Northern Justice Watch. She's a community organizer, human rights advocate, and documentary filmmaker with a mixed heritage that includes a patrilineal Tigrayan kinship. Following the outbreak of war in Ethiopia in 2020 and the escalation of atrocities against civilians in Tigray, Joanne stepped into advocacy work focused on peace, justice, and well-being of the Tigrayan people. She is a founding member of the Alliance of Genocide Victim Communities, a survivor-led coalition established in collaboration with representatives from the Tigrayan, Tibetan, Tamil, Uyghur, and Tutsi communities, and now expanded to include Hazara, Rohingya, and Yazidi communities. Through cross-community collaboration, AGVC creates opportunities for shared learning and works with decision makers to address shared patterns of harm, strengthen responses to human rights violations, and support the well-being and participation of affected communities in Canada. Joanne also serves as a board member of Ethiopian Canadians for Peace and the Canada-Tibet Community. She's a member of Tigray Advocacy Canada and sits on the advisory board of Northern Justice Watch. She is currently pursuing a master's degree at the Tyndale University, where she is exploring the intersection of faith, justice, and healing in the context of violence and displacement. Her most recent film was produced in partnership with the Canadian Centre for Victims of Torture, is titled Resilient Genius, and explores the impact of war on children and youth by amplifying their voices and immersing the viewer in their experiences. And thanks for being here again. And if I miss anything about introductions, you feel free to add if there is something relevant. And yes, without further ado, I will start the session. And first speaker will be Toby Mandel. And the topic is legal challenges in prosecuting atrocity crimes and strategic litigation. International human rights law, international criminal law is a fairly complex topic for those who are not already familiar. And I will give the stage to Toby Mandel for about half an hour to talk about this topic. Toby, please.
Well, I'm trying to share my screen, but I'm not. When I flip up the thing, I'm not really getting the files to show. Oh,
okay. Do you
I don't know if you need to give me a different sort of access to sharing, or you can share it.
Sure. I can also share it. If that's okay. Yes.
Yeah.
I have the presentation on already, and
just while you're getting that up, I'd just like to mention that I'm going to, I've got quite a few slides. There's like 21 of them, and I've got half an hour to speak. So I'm not going to go delve into detail on all of the slides. I'm going to skip over or pass quickly through some of them, but you will still be able to get the copy of the slides afterwards. So
okay, sounds good.
If we go to the next slide. So the two things I'll be talking about in this presentation, the first is challenges in prosecuting atrocity crimes. The main theme here. And then I'll just say a few words at the end, a few slides on strategic litigation, what it is, and how it can be used. And I'd just like to say, I mean, Ennis mentioned a couple of times human rights and international criminal justice, but my focus here is really on international criminal justice, not so much on human rights, although, of course, human rights kind of overlay everything, including the rights of the accused. So the next one.
Yes.
So I spent a little bit of time, and these are some of the slides I'm going to skip through a little bit more quickly. I'm going to spend a little bit of time, defining what these atrocity crimes are under international law, just so we kind of know what we're talking about here. And these are really the three most serious crimes of concern to the international community, and taking into account their scale, their severity, and the intent or the aims of those who commit them. And the specific crimes are genocide, crimes against humanity, sometimes abbreviated to CAH, and war crimes. And in terms of how they're defined in international law, the most dominant area to look for them, I guess. They existed before this statute, but the Rome Statute, and it's just one Rome there, I don't know why I put two in there, the Rome Statute of the International Criminal Court, which established the International Criminal Court, and that defines the crimes which fall within the jurisdiction of that court, and those are these three atrocity crimes and one other crime, the crime of aggression, or of states using armed force against others, going to war. So going to war is not part of the atrocity crimes, and we're going to focus on the first three. Next slide. So just to clarify, I mean, if you want to secure a conviction for a crime, each crime can be broken down into specific elements or parts, and each one needs to be proven to get a conviction. Different crimes, the elements are defined based on the crime, but every crime requires proof both that the accused person did the act, the physical act which constitutes the crime, they committed a murder, for example, and that they had the mental guilt required. So, for example, if you there have been cases where somebody was sleepwalking and not in control of themselves, and they committed a crime. So they were absolved of the crime because although they certainly did the crime, the act, but they didn't have the mental guilt or the mental element. And people talk a lot about the idea of being incapable of bearing the guilt, so that being absolved on the basis of insanity is sort of the layperson's term for that. So there are various mental elements, and those both have to be proven. And the exact mens rea requirement can vary. At a minimum, it's going to involve the intention to do the act. So the person who's sleepwalking and commits a murder didn't intend to do the murder because in this case, they weren't in control of their own body. But sometimes there's a more specific intent requirement. So, for example, we talk about first-degree murder. That's a murder which is premeditated and where the intention is of a higher level than just simply a murder. So, and we're going to see with genocide in particular the intent there. And often the mental element is the most difficult element of the offense to prove. You can prove that the thing happened, somebody was murdered. Of course, you have to prove that the person you're accusing was the one who committed the murder. So that's another factual element. But then proving, the intent can sometimes be difficult and harder to get evidence of that. Next slide. So as I mentioned already, there's a specific intent requirement for genocide, and the intent is to destroy in whole or in part a national, ethnical, racial, or religious group. So just going around and killing people randomly would not qualify as genocide. You would have to kill those people as part of a desire to eliminate at least part of the group. And then there are specific acts which qualify as genocide, 5 different types of acts. So killing people, causing serious bodily or mental harm to people, inflicting conditions designed to bring about the physical destruction of the group, for example, starvation, measures aimed at preventing births. Obviously, that will eliminate a group over time, and forcibly transferring children out of the group. So again, that will eliminate the group over time. So that's genocide. Next one. Crimes against humanity. So the key importance of crimes against humanity is that it applies whether it's part of an armed conflict or it's in time of peace. So unlike war crimes, which require an armed conflict, crimes against humanity can take place in a perfectly peaceful situation. They involve a widespread or systematic attack against civilians, involving multiple commissions of the underlying crimes. So not just a single crime, no matter how serious, and that systematic activity needs to be, and these are quotes from the ICC statute, they have to be pursuant to and furtherance of a state or organizational policy to commit such an attack. So there's a plan, there's a policy to systematically attack civilians. The individual that's accused of a crime against humanity only has to commit one of the criminal acts involved. That person doesn't by themselves need to be involved in multiple crimes, but they need to be part of a broader pattern of those crimes. And again, we have a specific sort of intent. The perpetrator must have intended to further the widespread and systematic attack. So, they weren't just sort of things happening in a context and they randomly did something. They have to be part of it. But they don't need to know all of the details of that plan or policy. They can be sort of a pawn further down the command chain, as it were, but they need to be involved in the systematic attack. Next one. So there are 11 serious underlying crimes that make up crimes against humanity. So murder, extermination, torture, rape, other serious sexual violence, and so on and so forth. And I'll just single out one, persecution. And persecution is a severe denial of fundamental human rights. And here there is an additional intent requirement that the perpetrator must have acted with discriminatory intent on the basis of some listed and then other grounds. So when you were accused of persecution, which is I would say a more general sort of activity than some of these others. I mean, sexual violence, deportation, unlawful imprisonment. These are very specific acts. Persecution is a more general denial of fundamental human rights. It's a broader category, but its scope is narrowed considerably by the specific intent that's added to it. Next slide. War crimes. So these are serious violations of the laws of war. So there are the laws of war is a very detailed international humanitarian law, a very detailed body of law. Not all breaches of the laws of war are war crimes, only the most serious one. And the Rome Statute essentially codifies war crimes which are applicable in international armed conflicts, like the wars that are going on in Ukraine and Iran, and a less extensive list is applicable to non-international armed conflicts, so conflicts that are taking place inside of one country. There must be an armed conflict, as I said before, and there must be a link, a nexus between the criminal act and the armed conflict. So an armed conflict, a civil disturbance, for example, a riot, so you have a demonstration and then it gets out of hand and people start rioting, that will not qualify. Things that happen in that context will not qualify as war crimes. There has to be an armed conflict, even if it's an internal armed conflict. Next one. And here's a list of some of the types of war crimes. I'm going to skip on to the next one. So, when we look at redress for these, and most of my comments that come after this are going to look at this, under international law, states have obligations to prosecute certain international crimes. Normally, countries only prosecute crimes which they have jurisdiction over, either because the national is from their country, or because the events took place in their country. But these atrocity crimes, which are universal crimes, those are considered to be within the jurisdiction of every country, because the nature of those crimes is so serious that it's an attack on the international community as a whole. So if a Canadian commits a murder in Canada, that's of concern to Canada, but it's not necessarily of concern to Germany. It's a matter for Canada to deal with. If a war crime takes place in Canada, that's considered at a higher level, and it's considered to be of interest to the whole world. And if Canada doesn't deal with it, then other countries can. And as the second point there notes, this is used when other bases for jurisdiction, the normal bases for jurisdiction, for example, the crime is committed in your country, are not available. And in Canada, we have the 2000 Crimes Against Humanity and War Crimes Act, and this empowers Canadian courts. It gives them a mandate, jurisdiction to prosecute individuals, regardless, for atrocity crimes, regardless of where the crime is committed, but the accused must be in Canada. So that's a limitation that you find in Canada, which is not found in all countries. It's an important limitation, so Canada can't prosecute somebody who we don't have physical jurisdiction over them. That at least resolves. So one of the practical issues with these crimes is imposing sanctions. So you can convict somebody, in a country, but if you don't have them, you can't impose sanctions on you. You can't imprison them if you don't hold them. So at least in Canada, that issue is resolved, because we will have custody over the person. But of course, a lot of these international criminals are not in Canada, so that's a slight problem. And as far as I'm aware, there have only been 2 prosecutions so far in Canada. And Sharp and Joanne, if I'm missing one or another, please jump in, or mention it in your own presentation. Both from the Rwandan genocide. One secured a conviction and one was thrown out because the evidence did not meet the required standards. So we're going to move on to that issue now. Next slide. So as I hope many of you know, there's a presumption of innocence under international human rights law and under most constitutions. In common law countries, that means that proof of the guilt must be beyond a reasonable doubt. So if there's any doubt in the mind of the trier of fact, the person should be let free. And it also has important implications for when evidence may be presented in court. There are very strict rules about evidence. And under common law, the key source of evidence is in-person testimony. That's the main primary source of evidence. And that person has to be subject to cross-examination. So somebody comes before the court, they present some evidence on behalf of the prosecution, and the defense lawyers can cross-examine them, can try to poke holes in their evidence. And that gives the defense the presumption of innocence, involves that power. There are many exceptions to this. Otherwise it would be pretty difficult to run cases, but that's the strong presumption. I will mention that civil law is far more forgiving in this regard. Civil law is nowhere near as strict about that. And as a result, I would say that Canada is probably not the best place to conduct atrocity trials. Of course, if the person's in Canada, that there may be a logic there for the trial to happen in Canada, but our rules of evidence and our systems of criminal justice are less friendly to securing those kinds of convictions than especially civil law countries. Next slide. And of course, a big part of the reason for that is that we allow for jury trials in many cases under our Constitution. any case where the maximum penalty is 5 years or more, aside from military cases, the accused has the right to select a jury trial. They don't have to. But and evidentiary rules are much more important in jury trials because juries, of course, are more susceptible to being swayed by evidence, I guess, than judges who are highly professionally trained people who are kind of, better able to deal with that. And I would just contrast that again, looking at a civil law country. In France, only the very most serious offenses involve juries, and France recently moved to pare that down significantly. And unlike in common law countries where the judges and the jurors sort of sit separately and discuss separately and operate separately, as you've all seen on TV, in France, they operate as a unit. So the judges and the jurors sit together and discuss together and decide things together. Furthermore, in France, you only need 2/3 of the deciding body to convict versus you need unanimous jury conviction in a common law system. Next slide. So it's not that atrocity crimes are difficult to convict. What's difficult is to prosecute a crime in a country other than where it took place. So if we're trying to prosecute a crime in Canada, which took place in Iraq or in Ukraine or wherever, there are, the evidentiary problems are significant in those cases. Obviously, it's far more difficult to collect evidence. We don't have police on the ground in those other countries. We may not even be able to get police over there because the other country doesn't accept that our police would be chomping around collecting evidence in their country. We don't know how things work in those countries. It's not easy for police to collect evidence about crimes anyway, but knowing the territory, as it were, is an important tool that police use. There are a lot of costs relating to translation, moving witness about, and so on and so on. The key issue, or a very key issue here, is witness testimony, and it can be very difficult to get witnesses over here to testify in person. So that brings us into the exceptions to the in-person rule. Next slide. Sorry, back, yeah. If you don't have the witness present, you can try to bring in the statement of the witness via an affidavit, which is a sworn statement before a justice of the peace or a similar official. This is an exception to the in-person rule, but it's an exception which exists in our evidentiary system. But where you bring in evidence like that, it's considered hearsay. So it's a third-party statement rather than a statement which is directly before the court, and it needs to be approved in a two-step process. First, the judge needs to decide on whether to admit the evidence at all. And that will be based on a combination of necessity. Do we need that evidence? For example, if the person's dead, that's the only way they could appear. Obviously, in atrocity crimes which took place in other countries, we can't bring all of the witnesses we might want to put on the stand into Canada. And then the second consideration there is reliability. If the evidence is less reliable, the judge won't allow it to be presented at all to the jury or to the court if the judge is the trier of fact. And then the second element is the probity or value. So once the evidence is before the court, so it has been admitted, it still may be given very, very little probity or very little value because it's not reliable enough. Even though it passes the reliability test on the admissibility stage, it can be considered highly reliable, a little bit reliable, or low reliability. So, and that is decided by the jury, but of course with instructions from the judge. Next one. Affidavits, these rules are essentially designed for the criminal justice system in Canada, and where an affidavit has been prepared in Canada by a lawyer and sworn here, that's one thing. It's quite a different thing to bring in a foreign affidavit under different conditions. For example, the country where the affidavit was sworn may have challenges with the rule of law, which creates reliability risks. Our justice of the peace are going to be fairly careful about swearing in affidavits. That's not the case everywhere. And just for example, you might get an official Chinese sworn affidavit, but if it's a political case, you're automatically going to have questions about the reliability of that affidavit. Different countries have different standards relating to evidence. So what would qualify as admissible evidence in another country may not be admissible under our legal system. So the affidavit may be good for that country where it came from, but it doesn't mean it's good for the Canadian legal context. Where non-professionals, and I'm using that word with a little bit of caution because, of course, lawyers should be trained and know how to take affidavits properly. It doesn't mean that they're the only people who can do that properly. Some civil society organizations have considerable expertise in that area. They know what they're doing. But if a non-professional takes an affidavit, they may in many ways undermine its reliability. For example, by asking leading questions, as part of the affidavit, or omitting key issues or whatever else. So the reliability of an affidavit that's gone through a proper process in Canada and the reliability of an affidavit from another country that may not meet those standards is an important barrier here. Next slide. And just to give you a sense of how careful the courts are about protecting against the admission of this kind of evidence. Section 26 of the Mutual Legal Assistance in Criminal Matters Act, the Canadian law passed by Parliament, allowed records or copies of records which essentially had been sent to our minister, so the Minister of Justice, usually in accordance with a request from Canada. So we're prosecuting a case, we need evidence, and the minister has asked a third state, and they have affirmed the reliability of that. So this rule said that evidence was admissible. So they overruled the test that I just described about admissibility. And then the trier of fact would still assess how reliable that evidence was. That was struck down by the Canadian courts as a breach of our constitutional guarantees of the right to life, liberty, and security, and of the presumption of innocence. They said, no, we need to stick with the test of whether this thing is going to be admissible at all. This basically got around the admissibility part of the standard. So I think that shows that we are, there are serious barriers to loosening the evidentiary rules in this case. Courts will not accept that based on our constitutional guarantees, especially the presumption of innocence. Next one. Okay, so the digital evidence has slightly other reliability issues. For example, whether it has been tampered with. So, if you have a picture, a digital image, if I take a picture on my camera and I immediately verify it and put it before a court without anyone touching that camera, that's one thing, but normally that doesn't happen. It's not so easy to take it directly into court. The second after, and by definition, there's a time lag. So there's a lot of ways to tamper with digital evidence, and proving the chain of custody over the evidence. So my camera never got touched by anybody else. That image never went anywhere else and was stored anywhere else. Could have been altered anywhere else. The chain of custody over the digital evidence is very important there. And normally speaking, that digital evidence, let's say I take a photo or a video, that still needs to be accompanied by an affidavit from the person, or by in-person testimony from the person who produced the evidence, saying how they, where they took it, when they took it, accompanying affidavit proof and things. So digital evidence, of course, is increasingly important, but additional care needs to be taken with it than other types of evidence. Okay. All right. So moving on in the last 3 or 4 minutes to strategic litigation. So I would define strategic litigation, and not just me, I mean other people as well. Unlike an ordinary case where you have the two parties, or more than two parties, and the issue is between them. Strategic litigation has broader social goals beyond the outcomes of that case. So although the case will almost always focus on harm to or a claim by a specific person or a group of people, but the goal is something bigger than that. For example, to change the law, send a signal to criminals around the world that their behavior will not be tolerated and that they will be brought before justice, whatever it may be, but something bigger. Um, and these cases are often associated with public interest or human rights issues, and these go beyond the interests of the client. And I'm going to come back to that and say a couple of words about that. And as I mentioned, it may seek a legal change, striking down a law, clarifying a law. It may seek to raise public awareness, support advocacy, or trigger a policy or legal change outside of the court process. For example, a very high-profile case can galvanize the parliament to pass a law, even though the case doesn't strike down a law or whatever. And I mean, the power of strategic litigation really hinges on the power of court cases to attract media and public attention, and also, I would say, sometimes, not always, to present key issues of concern in a clear and powerful manner. Court cases, rightly or wrongly, attract a lot of attention. Next one. Yeah. So in the context of atrocity crimes, I would say, and these are just a few examples, but strategic litigation can be relevant in various ways. Of course, securing a conviction gets justice in that case, but it might send a warning shot to would-be criminals around the world. And we have this expression, the wheels of justice turn slowly, but grind exceedingly fine. The message is, it may take a little while to get you before a court, but we're going to get you and grind you up, I suppose, in this metaphor. Successful cases can also lead to a greater rate of prosecution, but of course the opposite is also true. If cases are unsuccessful, prosecutors are going to be more, shy of bringing them. These cases, of course, shine a spotlight on the abuses, atrocity crimes, prosecutions in Canada, like those two Rwandan cases, there was a lot of media attention, a lot of discussion, a lot of public debate around them, much more so than, if the case hadn't happened. Successful cases may bring some solace to people other than the victims and their immediate relatives. So, people, even though they're not involved personally in a case, may think, okay, at least some justice is happening. And the cases may lead to interpretations of the law which make it easier to bring cases, but of course, that can run the other direction. And in the Section 36 case that I just talked about, I don't think that was a strategic litigation case, but obviously, that did not make it easier to bring atrocity crime prosecutions in Canada. That law was passed in part to facilitate those prosecutions, and the court said, no, you're making it too easy. We're not going to accept that. So, that can run either way. Next slide. And I mean, from my point of view, a well-planned strategic litigation strategy should normally involve more than just the case strategy. So you have the case and you're doing the case, but depending on the objectives, it could be accompanied by a communication strategy. You want to maximize media and other public attention. It can also involve a wider advocacy strategy if you're hoping that the case, for example, will prompt Parliament to consider a law or something like that. You may want to develop some policy or law reform elements to accompany your case. So your case is going to, strike down a law or perhaps point to the absence or a gap in the legal system, and you have something to fill that. You've developed that as part of your strategy. And I would say that a lot of times civil society groups are involved in these cases, of course, not always, but where they are, they can probably manage these elements of the case better than lawyers who aren't always involved in that kind of activity. Next slide. And I mean, some things to think about before launching a strategic litigation case. Do you have the resources to allocate? Cases can take a very long time. They may involve appeals, possibly multiple appeals. Can you be there for the long term? And while the prevailing image of a strategic so this dramatic win, slower, smaller wins are probably more often what happens. So you may need to manage expectations and be there for the long term. You need to consider the risks of backfiring. What if you lose the case legally? But you may also find that although you're trying to promote public sympathy or public, positive public views based on what you're looking at, that may backfire and the public may see things differently. So I think you need to kind of keep your eyes open about that possibility. And you need to think a little bit carefully about clients. Now, this is less true in the criminal justice context by nature of that. But the client's interests and the wider strategic litigation objective may not be perfectly aligned. For example, you may get involved in a case and this happens sometimes in environmental cases, for example, against an environmentally abusive company. The company offers the plaintiffs financial compensation, and they say, well, I'm going to take that because that's a lot of money and I'm going to take it. And then your case disappears. So, you need to think about that. I do have one more slide. It's about the steps to go through. I'm going to pass through that and I'll just go to the last one. Next slide.
Oh, sure.
Yeah, so just you have my email there in case you want it. You can contact me. So thanks. I hope I didn't go too far over time, and happy for any questions later on.
No. It was great. Thanks, thanks, Toby. Really, I personally learned a lot of new stuff here myself, so yeah, appreciate it. Next up, we have Joanne, and we're gonna have two sort of parts that are important primarily for now the Tigrayan community and the Tibetan community. First up, we'll start with the diaspora advocacy in Canada from the Tigrayan perspective, and so which will include challenges with evidence, witnesses, jurisdiction, and political barriers, which we just talked about with Toby. But how does that apply to the Tigrayan contexts? So Joanne, please.
Yeah, thank you, Ennis, and thanks, Toby, for laying out the legal framework with everything. And thank you again, Northern Justice Watch. You're always creating these spaces and sharing case studies and thinking through this. So appreciate that. And I want to start by saying, kind of like I did last time, actually, I think I said something like this. Disclaimer is that I'm not a lawyer. I'm a human rights advocate, a filmmaker, as was mentioned in the introduction, but I'm not speaking from a position of being a qualified lawyer. We work with great lawyers, and they have a different might have different insight into some of this than what I have. But I have been advocating since 2021, and before I speak about some of the legal challenges in the Tigray context, I just want to acknowledge that this is not a discussion about crimes that are safely contained in the past for Tigray. On August 1st of this year, this is just a couple of days ago, federal and Tigrayan forces were clashing in Western Tigray. It's an area close to the Sudanese border. Tigray authorities said it was the Ethiopian National Defense Force. A federal minister in Ethiopia said it was the TPLF that initiated the conflict. But what's not disputed is that there was heavy fighting that returned, and in one of the most serious breaches of the Pretoria cessation of hostilities agreement. So the current calm that's actually there today, settled down again, is exceedingly fragile. And as I speak, there are community and open source reports that are indicating that there's further troop movements and military preparations that are all along Tigray's southern border. The danger is immediate, and the arc of that did not begin just a week ago. We have already known now for about 6 months that there's an escalation of intense warning signs. There were clashes in January. There were flight cancellations. Public flights to Tigray were canceled. January 31st, there was a drone strike that killed a civilian driver. Federal military deployments, we saw this already starting in the south and the west. There's another reported drone strike in Shiraro in June. There's been a total fuel and budget restriction. All of this renewed mobilization, and the African Union, the UN human rights chief, a bunch of different crisis analysts, Tigrayan civil society, they've all warned that this very fragile peace has been falling apart. And then on August 3rd, that's just, a couple days ago, Amnesty International acknowledged violence has returned. They called for independent monitoring again. And none of this was hidden. These warning signs didn't even just begin in 2026. Actually, in October of 2023, the United Nations had an international commission for human rights experts on Ethiopia. And they applied the United Nations framework for analysis of atrocity crimes. And they found that all 8 of the common risk factors and a majority of specific risk factors for atrocity crimes were present in Ethiopia then. And they described it as acute risk for further atrocity crimes. They warned very real and imminent risk of further deterioration. And 10 days later, after they issued that report, the commission's mandate expired without renewal because of heavy lobbying by Ethiopia. So since then, we've seen what's happened in the Amhara area, the Oromo region, lots of trouble across Ethiopia. And then there's areas in Tigray, portions of the state, like the Irab area, that never saw a cessation of violence. They actually forced disappearances, gang rape continued. 60% of the state of Tigray has been occupied by forces that are hostile to Tigrayans since this whole thing started in 2020. So the situation and all of these warning signs were delivered and documented, given to institutions that hold the authority to act and to put pressure on Ethiopia, and some have. But the response has never been enough to actually prevent what it is that we're seeing. And I think that they never really addressed the underlying reasons for the tension. They were not serious about actually establishing peace. And just as a reminder for those who don't know about the scale of the genocide in Tigray and some of the major crimes that were actually committed, before we talk about some of the challenges, let me just give you the high-level sort of view of some of what's happened. So between 2020 and 2022, the estimate is that between 800,000 and 1 million Tigrayans were killed. That's through in a 2-year window. Tigray is like the northernmost state in Ethiopia, which in Ethiopia is in the Horn of Africa. It's bordered by Eritrea above and a couple of other provinces underneath, and then Sudan. Despite the signing of the Pretoria cessation of hostilities agreement in 2022, there is limited access to the state today. And even with the limited access, there are academics at the Ghent University that were able to compile a list of 256 different massacre sites. And this is where 5 or more people were killed. Amnesty International, for example, reported a massacre in this holy city called Aksum that left 800 people dead, included the door-to-door killing of all males over the age of 7. And there was clearly in the crimes that were committed an intent to break the social fabric in Tigray. Each account that we were receiving is riddled with horror. It's things like parents being murdered in front of their screaming children, church congregations targeted, reports of these white cotton-clad Sunday school children having just emerged from communion being executed in front of their mothers. And then in addition to this, the sexual and gender-based violence, which has been really a hallmark of the Tigray genocide. Just to give an idea of this, the population of Tigray before the war, we believe, was somewhere between 7 to 9 million people. And there's a reason why it's a vague number, but somewhere around that. There's a commission of inquiry on Tigray genocide, which is a body that's created internally in Tigray. And they surveyed 480,000 women and girls, 480,000 women and girls. And from that sample of 400, it's actually 481,200 girls, whatever, but I'm just rounding the number. So it's not 481,000 women and girls. And of that, 152,000 women and girls were raped of that sample size. And if you broaden the scope to gender-based violence, it's 286,000 of the 481 had experienced at least some form of gender-based violence. And what we're talking about is like the UN Deputy Secretary General at the time, her name was Amina Mohammed. She heard firsthand stories. And she said, women were affected in a way that is, quote, unimaginable, and went on to say, in your worst nightmares, you cannot imagine what has happened. I listened to women who had, and then she stopped and she said, I don't know how they managed to tell us again the stories of the atrocities that were committed against them. Most of them were gang raped. There's forms of sexual slavery. It was genocidal in nature, clearly, if you look at the language and what was actually done to them. So Tigrayan women, some as old as 80, Tigrayan girls as young as 4, were targeted with this organized genocidal rape. Then in Western Tigray, which borders Sudan, there was a relentless campaign of terror and ethnic cleansing. People have still not been able to return, despite it's part of the Pretoria Agreement's documentation, essentially, and its requirements are that people should return. But that hasn't happened. And at the time, as Tigrayans were being displaced from their homes, there were bloated, tortured, mutilated bodies of Tigrayans washing up the Tikizi River, which separates Ethiopia and Sudan. Salon magazine at the time also published a report confirming that thousands of Tigrayans, including children, were being held in that same area in concentration camps. Those are their terms, concentration camps. Multiple accounts of civilians being executed in large numbers and dumped into pits. There's video of Tigrayan bodies being burned to remove evidence of their existence. And then in an investigative report, CNN indicated that the ethnic profiling and detention and killing of Tigrayans bears the hallmarks of genocide as defined by international law. And then as a result of these allied forces not only destroying, but they were looting Tigray as well. 80% of the medical facilities were rendered non-functioning, farming equipment, livestock, mill houses, factories, water treatment facilities, water wells were all destroyed. Even fruit trees were chopped down. And the actions combined resulted in Tigrayans experiencing a man-made famine, similar to the one that 40 years ago, many Canadians first became familiar with Ethiopia because of there was a famine that sparked Live Aid and Bono and David Bowie and all of that. This famine was similar in Tigray. And then in June 2024, we have the New Lines Institute, an independent non-government organization, concluded there's reasonable basis to believe that genocide has been committed against the Tigrayan people. February 2026, the American Bar Association called for accountability and prosecution of war crimes, crimes against humanity, and genocide in Ethiopia, and warning of this renewed escalation in Tigray. So I just wanted to say all of this and give that summary, but say that what's missing is not actually knowledge or actually even evidence, it's action. And I can't stress enough that this is what impunity looks like. What it looks like when it moves from the past into the present. And so for me, this talk is not just about prosecuting yesterday's crimes, but it's about how the failure to prosecute crimes is actually helping to make today's crimes and tomorrow's crimes actually possible. And with that, let me say, we've had a lot of evidence that's actually been gathered about the crimes that have been committed. It's difficult because there are real barriers to evidence collection and to justice. The perpetrators of the genocide, one of the perpetrators, is the federal government, and the federal government of Ethiopia is still in power. It continues to deny access to Tigray. Why would it allow evidence of its own crimes to be gathered? And so they have not only been like uncooperative with the UN International Commission of Human Rights Experts, and Amnesty and Human Rights Watch and other investigators, they've actually actively undermined them, and they also threaten and kick out and detain journalists for writing reports they don't like. They've kicked out Doctors Without Borders. They kicked out the Norwegian Refugee Council for telling the truth about what was happening in Tigray. So, of course, they don't want to allow investigators into Tigray. But there are important efforts to collect and preserve evidence, including the Tigray Genocide Commission, and there's other ones as well that are happening at the same time. But that doesn't compare to situations where there are political changes at the top, like Rwanda, for example, and what could be achieved if you had unhindered access to Tigray and a cooperative government. Another barrier has been jurisdiction. Toby was mentioning some of this, but so Ethiopia and Eritrea are not state parties to the Rome Statute, and that means that the International Criminal Court does not have ordinary territorial national jurisdiction over crimes committed in Tigray. There are pathways that could arise through ad hoc acceptance or a referral by the UN Security Council, but the ICC is not a courtroom that victims can simply approach on their own. The Pretoria Agreement, which was a cessation of hostilities agreement, it called for a national transitional justice policy addressing accountability, truth, reconciliation, healing, things like that. Ethiopia adopted a policy in April 2024, but it was riddled with problems. Its scope, its mandate, very unsurprisingly, the implementation has not delivered a credible accountability process at all, and it is essentially abandoned. Tigray also did not participate in it, partly because the Ethiopian government was really in charge of everything. Independence was always a central concern, and Eritrea was also actually not included in the cessation of hostilities agreement, the Pretoria Agreement, etc. So, and then here we are with, there's universal jurisdiction, and universal jurisdiction matters. In March 2025, 8 survivors did file a complaint against a complaint with the Germany federal public prosecutor alleging war crimes, crimes against humanity by 12 senior Ethiopian and Eritrean officials requesting an investigation. That's an important step, but this so far is just a complaint. And Canada has legal roots, as again, Toby was talking about Section 6 of the Crimes Against Humanity and War Crimes Act. Section 8 permits prosecution where specified Canadian connections exist at the time of the offense. Canada's War Crimes Program brings together the RCMP, Justice Canada, CBSA, Immigration, Refugees, Citizenship Canada, and there are tools that include criminal investigation and prosecution and immigration measures that could be executed. But it's just the existence of the statute is not the same as an accessible pathway, essentially. And cases still require so many bits and pieces, jurisdictional connection, and the evidence, the identifiable suspects Toby was talking about, importantly, and research, resources, and prosecutorial willingness really are very important. Some of these other tools can be helpful, but they have limits. And the Alliance has, the Alliance of Genocide Victim Communities, for example, has advocated for some things like targeted sanctions and immigration measures. But we have to think about our resources and strategizing what it is that we can do with what we have in each case. And last talk that I had with Northern Justice Watch in the last seminar, we talked about justice being like a cathedral, and how it takes many years to actually, formal justice really takes a long time and many moving parts in order to actually be constructed and become complete. And but we can each play our own roles. Let me just quickly end by saying transitional justice, which is really the way that communities respond to serious past abuses and how they find truth and accountability and healing and reconciliation. it has these 6 dimensions. We talked about this in the last presentation also. Restorative justice, which is repairing relationships. Transformative justice, which is changing the systems that cause the harm. Preventative justice, which is ensuring that violence can't happen again. Epistemic justice, which is restoring the voice and credibility of survivors. Distributive justice, which is repairing injustice in resources, land, opportunity, and power. Courts matter and accountability matters, but the courts can't be the beginning of the whole justice. They're one of the last and slowest stages, and communities are really first, and institutions follow decades later if they follow at all. Our ability to document is important. Documentation is actually like a survival act. Healing can begin immediately by listening to one another. It's epistemic justice and aspects of restorative justice that begin right away. If we wait for political change to begin, it's like waiting for rain during a drought. There are things that we can do today. And Tigrayans have documented, translated, preserved memory, supported displaced families. They've testified, they've organized across borders, they've created space to listen to one another, insisted that others listen to them. And to be heard is one of the deepest needs of victims, and survivors know truth before institutions do. But internationally, we haven't done everything that we can to uphold international law or defend our values, and we've not been serious about peace or establishing peace. A cessation of violence is not the establishment of peace or the conditions for peace. So to conclude, I'll just say some things quickly that Canada could do. Canada should absolutely be pressing for an immediate halt to military operations and emergency African Union-led talks. Verifiable implementation of the Pretoria Cessation of Hostilities Agreement would be good. That means independent monitoring, humanitarian and media access, protection for civilians, public accounting for military activity. And the federal government and the Tigray officials both have to comply with international law, obviously. There's also opportunities ahead in Canada. Said they were launching a 2026 Africa strategy and included a promised diaspora engagement channel, essentially. There could be a permanent, confidential, multilingual accountability channel that could be kind of woven in there. If you're really going to be talking to the diaspora about things that matter to them, this is one of the things that matters, not just for Tigrayans, but many other areas across the continent. And diaspora consultation, I think, should not be just another listening exercise with no institutional destination. We've had lots of those. People listen and don't do anything, or refer to an institution that can actually do something. There are offenders present in Canada. There are victims with Canadian connections. There are financial and corporate links. There are evidence holders that are located here. And Canadian authorities could be more proactively screening for some of those. It's expensive, but it's something that could be done to uphold our values. Canada and its partners could also support survivor-centered documentation that is already happening, whether it's training them better, but recognizing that the current danger makes preservation preventative. If you preserve the evidence, is preventative as well as retrospective. That's a really important. And then finally, Canada's relationship with Ethiopia can, and I believe it should be tied to civilian protection. We want to uphold our values. Ethiopia is always in the top 2 or 3 aid recipients from Canada in the world. We don't want to unintentionally cause harm by supporting a regime's programs that are intentionally excluding or participation of a whole ethnic group. And I think that all of us, friends, diaspora, we can speak up for those suffering in Tigray. We can amplify their calls. We can hold Canada responsible for how we interact with Ethiopia and what it is that we're actually funding. And justice, can be started by those of us who basically refuse to wait for permission. And so I think with that, I'll end. I see I've got like a couple seconds left. So thank you.
All right. Thank you very much, Joanne. And In my time with Northern Justice Watch too, and I was educating myself on the atrocities against the Tigrayan people, but you've added a lot of the stuff that was unbeknownst to me, and I think to a lot of people as well. And just at the end, good point. In terms of foreign aid to these countries, is it unconditional? And really, the intentions are good, like say in Canada, but again, even quote unquote maybe unintentionally harming people abroad is a real possibility, and I think and maybe Sharap would have similar maybe inputs on that topic as well. And next up we have the same basically topic, same challenges, but from the Tibetan perspective, and for that Sharap will help us for the next about 20 minutes. Thank you, Sharap. You're muted. Sorry. Yeah.
Thanks, Enes. Thank you so much. I would also like to begin with a disclaimer that I am not a lawyer. I do not have any legal background. I'm a human rights advocate for Tibet, and I'm really pleased to join legal expert Toby Mendel, my colleague Joanne Hodges, and Enes. Thank you so much. So for today's topic, I wanted to touch upon the recent introduction of China's law called Ethnic Unity and Progress Law, and how it would be used to block any sort of international concerns raised against human rights violations committed by China. So there are very few forums, as we know, exist to hold China accountable for its human rights violations. It's not a party to Rome Statute of ICC. It holds veto in the UN Security Council. And in the few forums that do exist, atrocity litigation depends on evidence, as mentioned earlier by Toby. And Tibet is one of the most closed territories in the world. Independent investigators, journalists, UN special procedures are denied access. Documentations have to rely on satellite imagery, leak official materials, or testimonies from those very few who managed to escape from China's super strong control and surveillance. Witness testimony is the very fragile link, because their families who are still inside Tibet face reprisals for their statements of relatives who could be outside. And so the people who even would like to, otherwise speak and testify on situation inside Tibet, they have to think twice, because their friends and family's safety cannot be protected by them. Freedom House, US-based institute, has ranked Tibet with the overall score of 0 out of 100 for the third consecutive years as the one of the least free region in the world, along with the South Sudan. And even North Korea has a higher score than Tibet. North Korea, according to the Freedom House, ranks 3 out of 100 in the Freedom Index. And so in light of such situation, many of us, including rights group like Canada Tibet Committee, when we call out China's human rights violations, we refer to international treaties such as International Covenant on Economic, Social, and Cultural Rights that China has ratified, the Convention on the Rights of Child, the International Covenant on Civil and Political Rights, as well as China's own domestic constitution, its own internal law, that actually, in theory at least, promises certain rights to the ethnic minorities, including to Tibetans and Uyghurs. So these are the few areas where we do invoke those treaties and in China's own constitution when we raise concerns about in Tibet to the Canadian government to the international institution. But the little window of opportunity that we had was kind of shut down with now a more legal mandate that China imposed very recently with this benign sounding name called Ethnic Unity and Progress Law. So I wanted to discuss today as a presentation, what does this law mean? And it has various aspects, including a transnational aspect, which could be used to silence any international community, including, rights group like us, we're here today. It could be silenced just by accusing us of promoting disunity in China. So, Enes, if I may share my presentation, I can, I'll share it here, see if I can. Oh, I don't think I can, but do you have access to my presentation?
I may not. Could you send it over to me?
Okay,
Yes.
okay, let me share it here.
Yeah, once I have it, I'll project it.
Okay. Okay.
If you could
Yeah,
upload it
I
to
send
yes.
it to the group chat.
Okay.
It's in the chat.
Yep. Thank you, Toby.
Okay. Okay, give me a quick second. It seems like you actually have sent it, but it doesn't display that message on my screen for some technical reason. So if you could please upload it again, because I'm having a technical issue right now.
I just dropped it into the
Yes.
Zoom chat. Can you not see it there?
Oh,
Can
yeah.
you check the chat box of
Okay.
the
Yes.
Zoom link?
Okay, it's all good now. Yes, thank you. Okay. Share. All right.
Okay, thank you. So, before I, begin with the presentation, just a really quick overview on Tibet, a region that makes up almost a quarter of entire People's Republic of China, with the approximate size of 2.8 million square kilometer, which almost is equal to Ontario and Quebec combined. So it's a massive piece of geographical region, considered very strategic for China. It borders two of the most populated regions in the entire earth between India and China. Has become a source to over 80% of China's reserve lithium that is being used in the Chinese electric vehicles. Holds the largest collection of fresh water, and source to some of the major rivers in South Asia. So it's a really strategic region that China, the PRC, after its formation in 1949, took over after forcing Tibetan representative to sign what was called 17-point agreement in 1951. And since then, through a series of actions under the disguise of, what they call liberating Tibetans, but basically, of course, starting with taking away the lands, taking away the resources, and in the last few years, especially since the Chinese President Xi Jinping came into power, there has been more systemic attack on the identity of Tibetan after pretty much extracting every possible resources there is in Tibet, after forcing millions of Tibetan nomads to move and give up their lands, and those lands being used for mining activities. And now the latest step of attack has been on the identity of Tibetan people. And so this year, on July 1st, as shared on the screen, China basically implemented what is called Ethnic Unity and Progress Law. And what it does is it has 62 different articles drafted in the language of unity and progress, who would be against, unity, who would be against progress. So very benign, sounding an odium name. It was passed by a rubber stamp parliament in March 12, 2026. Next slide, please. So without going into every 62 articles, some of the more important article that has implication on the identity of Tibetans, Uyghurs, Inner Mongolians, and many other, China claims there are 50 ethnic minorities in China. So how does this law actually, impact the ethnic minorities in China? Article 15 is connected to the language. Priority, quote unquote, the national standard spoken and written Chinese language. So Mandarin is understood by the PRC as this Chinese language, but it doesn't specify that Mandarin is the Chinese language that they're referring to. But in theory, at least according to the Chinese own constitution, the languages of all other ethnic minorities are also considered official languages. In case of Tibet, the region that I just described earlier, 2.8 million square kilometer, bifurcated into now Tibet Autonomous Region, and then 4 Chinese provinces of Qinghai, Sichuan, Yunnan, and Gansu. So in theory, those regions are promised the space to promote and learn and practice languages in their own mother tongue, in this case, Tibetan. But the Article 15 clearly says the national standard spoken and written Chinese language. Article 6 is focused on identity. A sense of community for Chinese nation becomes the foundation of unity. Every distinct people subordinated to one party defined identity, which is Han Chinese. Article 20, refers to the family. The parents must raise children who love, the Chinese Communist Party and avoid teaching anything, quote unquote, detrimental to the ethnic unity. Article 54, civilians, citizens, including children, are invited to report violations, echoing the Cultural Revolution era practices when during the late era of Mao Zedong, the Cultural Revolution took place, resulting into deaths of millions of Chinese across PRC. And so we're starting to see certain, signs of those era where, citizens are forced to spy on each other. And finally, the most concerning, at least for foreign citizens, citizens of a sovereign country like us, the Article 10 and 63, it says foreign organization and individuals can be held legally accountable for undermining national unity. And this particular article was actually recently spoken by Canada's former Deputy Prime Minister and former Foreign Minister Chrystia Freeland in Taiwan raised concerns about this article. And Canada also spoke about the law itself in United Nations very recently. And I also, before I forget, I also wanted to mention that a Tibetan American recently, a day after the law itself was implemented, forced into on July 2nd, and on July 3rd, a Tibetan named Lobgar Rangzin, he self-immolated, burned himself to death in front of United Nations headquarters, trying to draw attention from the international community and calling, among other things, calling for the repeal of this ethnic unity and progress law. Next, yes. So as I mentioned earlier, this new ethnic unity and progress law, it breaks, contradicts several international convention treaties and China's own legal order, starting with the International Covenant on Economic, Social, and Cultural Rights, the Convention on Rights of the Child, and also International Covenant on the Civil and Political Rights, whose spirit China must respect as a signatory. And in the case of ICECR, China has ratified. Global education standards, it defies this ethnic unit, defies the UNESCO Convention Against Discrimination in Education, which is the benchmark of international consensus. And then it contradicts China's own constitution, Article 4 and 121, as well as what's called Regional National Autonomy Law passed in 1984, especially the Article 37 in that law. So going into the International Covenant on Civil and Political Rights, on Article 27 states that minorities shall not be denied rights to enjoy their own culture or to use their own language, signed by China. CRC on the rights of child, Article 29 and 30, education must develop respect for the child's own cultural identity, language, and values. Minority children may not be denied their own language, something we see that China has completely disregarded through the forced separation of Tibetan children into residential schools now. And with this new law, it has basically legalized its ongoing action of forced separation of Tibetan children. Again, China has ratified this convention in 1992. Then in International Covenant on Economic, Social, and Cultural Rights, Article 1, all peoples have the rights to rights of self-determination, including free pursuit of the social and cultural development, which China has ratified in 2001 and has completely disregarded. Officially, legally disregarded through the introduction of this new law. So 3 treaties, 1 guarantee a minority may not be stripped of its language, list of all in school, and which China has completely disregarded. So covenant, conventions and other treaties exist. For China, it's just a theory, but in actual practice, it is, as I mentioned earlier, it has forced relocation of Tibetan nomads. It has forced separation of Tibetan children into residential school, forcing communist indoctrination, and now the complete obedience to this Communist Party ideology has been put into this new ethnic unity and progress law under the guise of what's called unity or the community of shared destiny, which is also part of China's foreign policy as well, not just the domestic policy. And then education standard, of course, as I mentioned earlier, UNESCO Convention Against the Discrimination in Education that China has broken and disregarded by forcing what is called a Han Chinese. In Chinese, it's called Zhonghua Minzu. So basically, through this new law, China has defined Chinese nation as Han Chinese nation, and forcing all other remaining ethnic minority into completely sinicizing, giving up on their distinct identity, something that countries like Canada has supported. Canada in 2024 passed a unanimous motion supporting the rights of Tibetan to self-determination, recognizing Tibet and Tibetan as nation and as people. But those international resolutions, those international covenants seem to mean really little to the increasingly aggressive and intrusive regime under Xi Jinping. There are some good examples. Canada has, of course, has a history of its own treatment towards indigenous, but in 2019, Canada passed the Indigenous Language Act and federal support for Indigenous peoples reclaiming and revitalizing their linguistic heritage, an act of repair for the forced assimilation of residential school, now recognized as a historic wrong. And whenever we have international institution or representative raising, finger to China about its treatment to Tibetans and Uyghurs, one of the counterpoint that China uses is what's your own history, how you treated indigenous. And I remember Canadian UN Representative Bob Ray said, at least we are practicing in the truth and reconciliation. We have acknowledged our history and we're trying to make up for those wrongs. But you have the existing practice, which could be, should be stop, not replicate what happened to the other indigenous community around the world. Quebec, a province with the significant rights of autonomy, has French language schooling for the last almost more than 40 years. For over 4 decades, provincial law has guaranteed education in French through the end of secondary school. Recognition that a language survival depends on its place in the classroom. And I put Quebec example because in theory, China claims Tibet as this Tibet autonomous region. The autonomy word is attached to it. And then the other Tibet, the traditional Tibetan regions of Kham-Amdo, which are now integrated into the province of Qinghai, Sichuan, Gansu, and Yunnan, have also the term autonomy attached to it. Tibet autonomous prefectures, Tibet autonomous counties under those provinces. And yet the real autonomy that we see in regions like Quebec or South Tyrol in Italy or Basque Country in Spain, those autonomy do not exist in China. In fact, the autonomy for minorities in Tibet, in China, are far lesser than people who live in mainstream cities like Beijing, Shanghai. So they have far more freedom. Next. And then China against itself, as I mentioned earlier, China has this law called Regional National Autonomy Law and passed in 1987. Article 37, states that autonomous areas shall independently develop education for nationalities, including, of course, it's referred to Tibetans, Uyghurs, Inner Mongolians, and others, shall, whenever possible, use textbooks in their own languages and use their languages as a medium of instruction. But in reality, when there are, strong interests, practice shown by Tibetans, there are more crackdown to control such display of, interest, passion to your own languages. A good example is a Tibetan documentary filmmaker and a Tibetan teacher named Tashi Wangchuk, who went from his hometown of Tibet, traveled all the way to Beijing, and his entire trip to Beijing was documented. He went to Beijing with a simple appeal that Beijing show support to the preservation and promotion of Tibetan language. He wasn't asking for separation, or he wasn't asking for anything that is not promised within the existing framework of Chinese Constitution. And yet his documentation of that trip and his appeal was enough for the authorities in Beijing to put him in prison for 5 years. And he was released only after there was completing his sentence, but also after strong international pressure. He continues to live, even after being released, continues to live with strong surveillance and control on his movement, which is common for many Tibetans, who speak and who get imprisoned, arbitrarily detained, and who gets released, sometime in poor health, sometime ending up and dying after being released from prison. Next. So finally, I would like to end on a note saying that the law that was introduced has given China a legal excuse to tell rest of the world, including the Canada, that you do not have right to what they call, interfere in internal affair. And this law would be used to say that you are undermining our national unity. If, let's say, if tomorrow Canada passes a resolution supporting the Uyghur autonomy or declaring what's happening in East Turkestan as the genocide, then China would say you're undermining our national unity, and because we have this new law. And so the already limited space for any international actions on China has been further controlled and further minimized. We hope more countries will speak out in repeal of this law. UN has asked, at the European Union, United States, and Canada in the UN office, a meeting has called for the repeal of the law. I hope that should happen at the earliest. Thank you. Thank you, Enes. I'll end here.
Yes, thank you. Thank you, Sharab. And if there's anything you further wanted to discuss, I think we can have some space for it in the next part. Now we will have sort of a more interactive part of this program with all three of our speakers, and I will ask Toby to please lead this panel discussion, which is going to be a comparative panel discussion of maybe what the Tigrayan and the Tibetan communities have experienced, in terms of litigation or any justice efforts so far in Canada, and maybe to lessons to draw and maybe other useful experiences. I will give the stage to Toby. Perhaps we can start with a leading question and can just maybe go with the flow.
Hey, thanks. I wasn't quite expecting that, but no problem. About how long shall we have this discussion for?
Let's aim for 15 to 20 minutes.
Okay.
Yeah.
Yeah, I mean, maybe we could start by asking both of you whether you see elements from each other's context reflected in your own. And I mean, Sharp, yours was quite focused on that law, which is a new development, of course, and things. But I mean, I'm sure you know a lot more about the general situation there. But Joanne, I don't know where you are about the Tibetan situation, but I mean, it kind of would be interesting to me to see if you see some parallels or differences. I mean, obviously, in terms of global power, China and Ethiopia, stand in different positions, but and the kind of the dynamic nature of the repression that's taking place in Ethiopia is very crude and physical, as opposed to a more, I guess I would say more sophisticated, more legal, but perhaps no less impactful in the end. I mean, impactful in different ways. Killing people, you can't beat that for impact, negative impact. So anyway, maybe just if you could each spend a few minutes talking about how you see the other situation as compared to the one you presented on. Maybe you could go first, Joanne.
Sure. I think they're really different contexts. I think that the impacts in some ways are similar, and even in diaspora communities to a certain extent. We see that, in the alliance, how similar it is when we're talking to each other about some of the longer term impacts of having experienced genocide sometime in your history and still being pressed in different ways. I think that, that the communities know what it's like to carry evidence and testimony and memory while institutions are doing nothing. Essentially, and I think that in some ways, what's surprising is that with China, they have veto power at the Security Council. They're enormously powerful, and like you were saying, comparatively, Ethiopia is a recipient of aid, and yet there's still this political roadblock, this unwillingness to actually hold accountable a country that is a recipient of aid. And so the lack of political will, and I think to me what just stands out is the way that how little we actually care about our values, our supposed values, and how easy it is to see through them when you see that in a situation where, yes, you have a giant like China, but you also have one of the top recipients of your aid, and you have incredible influence over, and you don't follow through and protect civilians or work genuinely towards a lasting peace. I think that it shows the self-interest of states, including Canada, essentially, and how we're willing to barter anything for our own interests. So I think in that sense, there's similarities, and it's revealing the contrast of the states' positions.
That's a very depressing view, and I'm gonna hope that you're wrong. That at least Canadians, as people, have some commitment to their values.
I agree.
And, perhaps our government is not always delivering on that.
I think that's the case, and I wonder about how, I mean, how do you trace, like, why is it that the values? I agree that, like, my neighbor cares more than the government does, and but it's, how do you translate that care into actually a national action, essentially, that's missing? And maybe you, in your experience at the director of the Center for Law and talking about democracy, like, how do you mobilize, so for example, let me just take one step back. Sorry, Sharap, next, but Canada has something like 450 ethnic groups, cultural origin. And then we have like 40% of Canada is either first or second generation immigrants. And that's an even higher concentration when you get into urban centers like Toronto, where it's something like 80%. So it's remarkable. And you have many immigrants who are coming here and they're fleeing violence. Diaspora politics matter. And, and then it impacts Canada in a way it doesn't impact Japan. For example, Canada's different. We are made up of these groups. So how does our government, like, why do we have to create public campaigns to simply have potential atrocity crimes and evidence taken seriously when it's impacting even our lives here in Canada, essentially? And those people who have been impacted abroad are coming here, living here. It impacts how we interact with each other. It impacts how we think about our institutions, how we are engaging. And so I wonder about that as a throwback to you, Toby, after Sharap. Perhaps the question is, like, what is that? What's a credible pathway that's to have experiences internationally taken seriously here in Canada, beyond our neighbors caring and actually having the government care in a way that is, perhaps it is their burden. It's more their burden than, because they're governing us. And we're here having experience.
Let's give Sheriff an in, and then I'm going to come back to you on that one.
I do see some similarities and, of course, some differences. As a co-founder of Alliance for Genocide Victim Community, one of the reasons that we became the co-founder was because we saw similarities in the fact that we were both, Tigrayans and Tibetans and other members of the co-founders of the AGVC. We're all minority group in our own countries being oppressed by majority. We all felt the sense of helplessness. And so we saw strength in numbers. I think the more united, the more people come together being oppressed by the bigger force. In a way, I think it's it's been in practice, in existence for centuries, that the powerful ones oppress the lesser powerful, the more vulnerable groups. It's this history of the greed versus the more the stronger, the more greedy ones oppressing the smaller ones. We see story of resilience, something that we see very similar, that Tibetans and Tigrayans have not given up despite facing a much powerful, stronger opponents. And in diaspora, as Joan mentioned, we come together asking for support from our chosen, host country, in this case, Canada. And sometimes we come together for a similar ask, whether it is a joint letter or a petition supported by a member of parliament, or something coming for events like this, organized by Northern Justice Watch, sometime coming together for Genocide Prevention Day. So it's, I think, a lot of similarity in a sense that we, it might sound very cliche, but we, a group that care for human rights, that we understand how it feels to be, treated as a second-class citizen in our own country, understand and sympathize how it feels to be helpless, um, being against a really powerful force. And some differences, as Toby mentioned, China is this massively powerful a country that is trying to be, next hegemon of the world. And it's already, the second most powerful country. And in some ways, it has already overpassed US in certain strength in terms of a GDP purchasing power parity. Its military economy is already, in some ways, it has already overpassed United States in its capacity. And so we are, we have been in our struggle for the last 66 years, and we have seen that each time it gets more difficult because China has grown stronger and stronger. And our path windows for, advocating for Tibet has become lesser and lesser as China has tried to shut down every international avenues. And we say our struggle is death by 1,000 cuts. We're not put, every thousands of Tibetans into prisons camp, and we're not being killed all at the same time, but we're killed in a very slow death by 1,000 cut, language being stripped, lands being stripped, nomads being forced from their lands that they have owned for thousands of years. Yeah.
Let me try to come back a little bit on Joanne's question and maybe make a little bit of observations. I mean, obviously, the global stature of the two countries in comparison is utterly different from, one of the two world superpowers, or perhaps three if you include India, I guess, to a fairly poor, if significant in other ways, African country that's a donor recipient or an aid recipient and things. And yet, and of course, the brutality of the Tigrayan experience is there it's one quick cut, or I mean, I maybe don't want to go down that metaphor, but anyway, I think if we look at Canada, and I'm speaking as somebody, I mean, I'm Canadian, grew up here, but I have lived abroad for extended periods, so I do have experience in other countries, and of course, I've been a human rights advocate pretty much all of my life. Which I won't say how long that is, but it's not that short. And I mean, I would just observe that right now, of course, is a not a good time in the world for anything good, if I can put it as broad. No, I mean that's a very broad brush statement, but this is an unprecedentedly terrible time. And I mean, and mostly, to be perfectly frank, that's coming from the attacks and disruption to the south of us, which is being, perpetrated on, I won't say every country, but a lot of countries. A lot of countries are like Canada. A lot of countries that might play a positive role in the world have been led to, I won't necessarily say force, but they feel forced to focus on bulking up their militaries, bulking up their own economies, protecting themselves against attacks from an erstwhile ally. And we've seen, massive diversion of public spending towards the military in Europe, in Canada, in Australia, many countries around the world, which we would hope to see as our allies in these kinds of struggles. So, that's the situation right now. now. And you know, a lot of the blame gets laid at the door of one very high-profile individual, but I think it would be naive for us to think that things are just going to get okay in 3 more years or 2.5 more years or whatever it is. You know, I think that this is a longer-term situation that we are going to be, as sort of human rights, as criminal justice, as you know, advocates. These are longer-term things. I think one of the challenges in Canada is that, I mean, you mentioned 450 different ethnic communities. I've not heard that term before, but or that number before. But anyway, we have an enormous number of different communities here in Canada, and many of them are facing challenges in their own countries. Some more extreme, to be sure, and the two that we've heard about today are in the higher registers of extremity. No question about that. No, not everyone's facing a genocide. Still, there are problems everywhere, and it's hard to kind of keep the focus on that enormous diversity of things. And then I'm going to say something which, I mean, you know, I'm a proud Canadian, but I'm going to say something a little bit negative about Canada and Canadians. I think that Canadians are very focused on justice and equality and those sorts of values in Canada, and they're not that much focused internationally. And you know, my wife is from Sri Lanka, so my in-laws are from Sri Lanka. That's a country with a very, very difficult history. They're aware of that, and they're, you know, conscious of that. But I would not say that because of that, they engage a lot in other people's struggles. They don't kind of carry that out in a way, you know, unlike, of course, that we do here. And I think that, you know, if I compare Canadians, I suppose, especially to a lot of European countries, I think people there have a much stronger, even though they're much less constituted by international, you know, first, second generation immigrants, but they still have a more engaged population on international affairs than we see in Canada. And I'm not quite sure where that came from, but I guess, you know, that's something you can convince your neighbor, because you probably talk to him or her regularly, and you know, you have access there. But you know, are you getting to the person 4 or 5 doors down the street, and the 110 doors down the street, and the, you know, the great majority of Canadians? I think it's not so easy to reach them, and you know, the collapse. I'm sorry to put it in those strong terms, but that is what it is, of the media here and in almost every other country, and its replacement by you know, essentially very dubious sources of information, you know, social media and whatever, and that also is you know, where people have great difficulty even knowing what's true. You know, even when they're looking at something, let alone what they don't know or don't care about at all, which you know, these two situations, I would say most Canadians, maybe they've vaguely heard of them, but you know, if you probe a little, scratch a little bit, they're probably not going to be able to say much about it. But even within that, I mean, even the things that they are looking at, you know, our information space is very, very troubled these days, and I think that a lot of people in Canada, like in other countries, just don't really know, you know, in any proper clear sense, what actually is going on out there. You know, apart from some, they know that you know, there's a war in Iran, and whatever. Probably most Canadians don't even really know that there's fighting ongoing in Tigray, and you know, they might have heard of Tibet, but they probably have no idea, you know, of the genocidal nature of it or anything like that. So I think there's, you know, there's some very, and you know, I mean, I think our government has a reasonably positive outlook to playing its role in the world, but of course it has to manage a lot of different things, and you know, the change in priorities recently is a challenging one for governments around the world to deal with. So that's a little bit of my thinking on it. What we need to do, I mean, you know, just keep raising keep talking about it, keep trying to lift it in the public debate. And strategic litigation is a good way to come back to that issue that we haven't really talked about too much, but that is a good way of getting things on the radar screen because cases do get talked about. John, did you want to jump in?
Yeah, I was going to say, I'm wondering your thoughts on, so the situation, for example, like if a community in Canada with a lawyer submits evidence for requesting a sanction, for example, because of they've compiled a lot of information in order to be able to do that. It's not like anybody can just do that. It's quite a bit of information. And technically, like currently in Canada, if you do that, there is no requirement for them to even acknowledge that they've received it, let alone follow up. And communities, diaspora communities, and those who are working with lawyers are spending a great amount of resource and time and energy to do something like that with no response. And that feels very undemocratic. It feels very, very, very much not like it should be changed. And I'm wondering your thoughts on that type of situation. And similarly, I know, for example, the Tutsi community here, speaking of the war crimes and the units that exist, they gave a lot of evidence to the RCMP. The RCMP opened a file, and then they actually told them that they went over to Rwanda in order to do some investigation, and then there's been no follow-up, and like years go by, essentially. And I'm just thinking about, this lack of accountability, essentially, that's what it feels like, from our own government that is a democratic government, and these bodies that exist that are paid for, by our government and all of that. How were your thoughts on those types of situations, and how do we address it?
Yeah. I mean, thanks for that question. I mean, I think it's going to sound a funny thing, but I mean, in most countries, the area where democratic mechanisms play out least is in terms of foreign affairs. So, we run our democracy inside Canada. We can effect change here. We have modality. I mean, not always, of course, and long way from a pure democracy at many, many different levels. But at least, that's an area where we have more sway, more democratic heft, if you will, as a group of people that should have some say. When it comes to international relations, that is, and that's not just in Canada. I think that's around the world. And I mean, I suppose that there are not to. I mean, Canada should not stand by quietly while genocides are taking place. And then sometimes they step up more. For example, Canada's sponsor of the case before the International Court of Justice about the genocide in Myanmar. Sometimes they engage more dramatically and more strongly. But I mean, it is a delicate thing dealing with international relations and managing all of the different interests at play, and things. And I think governments do reserve to themselves a lot of flexibility, a lot of discretion, notwithstanding what the people might think, less, much more so than when it would come to a domestic issue. That doesn't, but I mean, if you do manage to raise enough, I mean, I cut my teeth on advocacy when I was a student at McGill University from 1980 to 1984 on the anti-apartheid struggle. So, apartheid in South Africa, which of course was a, blatant and ridiculous abuse of everything that we all stand for. I mean, that did, sustained advocacy, broad-based, active university engagement, across the country, and at different levels. And it did lead our government to act more strongly and to progressively divest from South Africa, and then eventually, the end of the white apartheid regime. So I mean, there are cases where it can be successful. It just
And it's a process.
build a broad campaign.
It's a process, and I find that like there's different levels of response from a government depending. You have to advocate for anything to happen, and certainly there are impacts, many different impacts that come from advocacy in different ways.
Yeah.
But I guess I was thinking more about it, and that's very interesting. Didn't know that was sort of the area that you least see democracy basically is in foreign affairs. Thinking not externally necessarily whether they implement the sanction or whether they actually decide to prosecute, so much as accountability back to the communities that initiated it in the first place is kind of that question of like, how do we get them to say, look, yes, we've received the sanction request. We may or may not use it essentially, but we'll keep you notified. Or it's on our, we've got these sort of, the RCMP to say, look, we're not going to tell you the details of all that we're investigating, understandably, but we're going to give you some kind of update to say, yeah, the file's still active, that there should be some response to the communities.
Sorry, just brainstorming. I mean, maybe we should group together, and it would probably, a lot of people could buy into a campaign like that, saying that, when a community, I don't know how we would phrase this or develop it. When a community makes a sufficiently weighty request, there needs to be a response. That's a democratic result, and and that would be for any community. And we'd have to have some definition of when it reached a level of severity. Otherwise, everybody could send in a letter, and we could tie up government endlessly with that, but there would need to be some guardrails on when this was triggered. But I suppose a lot of us working on different campaigns might buy into that idea that part of democracy is that government doesn't have to do what you're asking, because after all, you aren't a majority, and whatever. And even if you were, you can't. That's not how our democracy works. But at least you deserve a response. I think that is pretty reasonable, and a sort of campaign that might take off.
Joan, if I may add on this, from our practical experience, in 2024, Canadian government imposed sanction against 8 Chinese officials, including 3 for their roles of human rights violation in Tibet Autonomous Region, and then the other 5, I think, for their roles in the against Uyghur people. As an advocacy group, we, of course, ask, and the sanction is one of the tools that we often, ask government to use it. But it was, we wish that we were consulted before government decided to choose the name or the final selection of those 8 officials, and we wish that we had been notified that they were going to sanction against those people, because what happened was that China retaliated by sanctioning us, not GAG officials, but sanctioned 20 Canadians, including myself, and 2 organizations, including Canada Tibet Committee and Uyghur Rights Advocacy Project. And this caught us by surprise, because we didn't know that government was going to sanction Chinese officials. Yes, we might have submitted certain names, months ago or maybe years ago. Maybe, other, advocacy group might have suggested. We don't know, but we asked after we were sanctioned, how did they come to this process? And we never received any clear answer on, what was the process.
Even in the context of you having been sanctioned, you didn't get any response.
No. But what we did receive was, we received quite a, I think I would say, good workshop and consultation on safety and security after we were sanctioned, how to secure ourselves, which we appreciate. But until this day, I really wished we would know, what was the decision-making process for selecting those, because out of the 3 officials that Canadian government had sanctioned, 1 was already ousted from the party under, I think, if I'm not mistaken, under the charges of corruption. So if they were going to sanction somebody, they might as well have selected someone who was still active. Here's a person who was already ousted from the party, under the charges of corruption. So I think that your question, I really think there should be a more transparency in the decision-making process of if the government at all is going to use sanction as a tool.
And the underutilization of diaspora knowledge that
Yeah.
you know that you're tracking because your family's being impacted, because you care about your community. You're
Yes.
tracking way more than
Not hard to
you
find
do.
you, is it?
Yeah, it's not hard. It's not hard. We're already lobbying. We're already in
Sure,
the
sure.
position.
Yeah,
You can
we're
find the
not just
advocates with the
victims. I
current.
I wish I totally agree with Joan. Sometime I wish, that government would see us as a partner in the
Yes.
decision-making process, not as, vulnerable diaspora group who are always sharing the, plights of their fellow diaspora groups.
Yeah, no, they absolutely should. That's true. I mean, to strengthen their own measures.
If I may, one thing I wanted to add is, and Toby, maybe you know more about this, is the Canada's War Crimes Program, which is interestingly short for Crimes Against Humanity and War Crimes Program. So basically, Crimes Against Humanity is stripped out from the long name, which that kind of makes me wonder if there's like a certain hierarchy of importance when it comes to the atrocity crimes. Hey, like, this is the worst, and like this is the least of our worries. Like, hey, crimes against humanity, it sounds less bad than war crimes, and to some people perhaps, and because we're more exposed to the term war crimes, like in media, and maybe crimes against humanity is less, I guess, frequently mentioned, say in media, and also on social media. And so my question was really, I think the war crimes program's budget has not been adjusted since 1998. And so to my knowledge, and please someone like fact check me, but it's not adjusted for inflation either. And so maybe the program's budget is actually shrinking year by year. Again, if my research is complete and accurate, this is the conclusion I reached. And is that the source of problems, or is it an indication of, say, a broader, maybe political or societal or any other cause? Like, is it sort of the chicken and egg? We really replaced the budget freeze for the war crimes program for over 2 decades. Like, where does that come from? Like, in your opinion?
Yeah, I mean, I don't know about that specifically, to be honest, and I don't know if some of the others analysts do. But in terms of the terminology, I'm going to guess. I mean, legally, there is no hierarchy among those crimes. I mean, they're all atrocity crimes. They all fall within the Rome Statute. I mean, genocide is generally considered to be, the worst, because it's an intentional targeted attack against a whole group. But even that, I think, is probably slightly loose thinking, and legally doesn't have any. There's no formal legal hierarchy there. I guess probably they use the term war crimes because it's short and catchy.
Yeah.
That's my
Okay.
guess, rather than
Yeah.
anything else significant. Does anybody else know about this budget thing? And I mean, what
Yeah, I know from I think that was true at least of last year. I haven't really looked this year, but I know for sure that was true up until last year, that the budget wasn't increasing, and to me, it's indication of the lack of political motivation to actually address any of these issues, unless there is a political fire to put out, essentially. So when you move, you really have to create a public outcry about something, and then you can see and I think that we haven't really had that, essentially. And then because there are communities that are tracking perpetrators in Canada, but there's no funds. There's enough funding, to really to resource all of these things. And so in some cases, I know that communities don't understand the pathways. They know that people are here, but don't know even how to potentially address it in Canada. And so I think that also education of like how you report and here, and that kind of awareness raising could be very helpful. But there really isn't the will to fund it and make that happen right now.
Yes. Well, thanks And first of all, like if we're slowly kind of wrapping up, let's say maybe in a couple minutes. And this was amazing, really. And though I have some formal education in international justice, but still a student here, so nothing really further to contribute. But really, and Joanne, like the first half of your session asked to kind of view that haunting summary of what's going on in Tigray, and that's what happens with impunity, is the case. And yes, really, I heard this number from I don't know who, but since the Genocide Convention in 1948, right? There's been, and to some scholars, there's been more than 50 genocides. And I think really like we talked about like two or three of them here really, but impunity, I guess in some capacity, in some aspect, has been the case since then. So that's why we're never seeing the end of it, right? And yeah, and really with Sharab too, that nationally, the terms such as unity and national identity and things like that is actually interesting. It's there's some I'm familiar with some other examples of similar legislation in other countries, so they seem to be learning from each other as well. But obviously in China, and it's on a larger scale, both against Uyghurs and Tibetan people. And yes, very interesting, very engaging conversation to me. I really enjoyed the comparative panel discussion that we just had. Thanks everyone. I will quickly check if we have any other questions from the community, and if not, then people. Yes. Okay. Yes, we've had most of our viewers on YouTube, and yes, really appreciate it. I may not be able to moderate the next one, but I will certainly attend the next one, which is going to be on Saturday next week, if I remember correctly. And so that's going to be the next live workshop. We expect everyone to attend that one as well. Without further ado,